The question before us today is both sharp and unsettling. Has the Indian judiciary remained the guardian of the constitution, or has it quietly transformed into a super sovereign beyond the checks and balances of democracy itself? Called the judiciary the sentinel on the Q-Vive, a phrase first invoked in 1950. We say the courts are the guardians of rights, the keepers of justice, the conscience of our republic. But let's ask plainly, who guards the guardians when the judiciary interprets, expands, and sometimes even rewrites the constitution? Is it still protecting the people's charter, or is it assuming the role of a supreme legislature? In one breath, courts have saved democracy, striking down Indira Gandhi's election case manipulation, protecting basic structure. In another, they have paralyzed executive power, entering into domains of governance, environment policy, and even budgetary allocations. Dr. B.R. Ambedkar in the Constituent Assembly warned us. The judiciary must be independent of the executive, but it must also not be a body that sits in judgment over itself without accountability. Today we examine the judiciary not as the reverend disciples, but as constitutional litigants. This is not a sermon of praise, not an indictment of contempt. It is a trial. The charge, judicial supremacy beyond its mandate. The defense, constitutional guardianship. The jury, you sovereign people of India. Act 1 is the original mandate, guardian, not ruler. Let us begin where every constitutional trial must begin, not in the courts of today, but in the chambers of 1946-49, the Constituent Assembly, a hall not of robes but of visionaries, men and women who had seen colonial law used as an instrument of repression. They knew that liberty without courts is fragile, but courts without limits are dangerous. The framers asked, what role shall the judiciary play in a sovereign republic? Shall it be a guardian? Or shall it be an emperor of law? The answer, my friends, was cautious, deliberate, and clear. Dr. B.R. Ambedkar rose in the assembly and said, there can be no difference of opinion in the House that a judiciary must both be independent of the executive and must also be competent in itself. Independence of the judiciary is the heart of the Constitution. But remember, the judiciary is not a body that sits in judgment over itself. It is accountable to the Constitution. Notice the balance. Independence, yes, but not supremacy. Guardianship, yes, but not governance. The Assembly wanted the courts to be protectors of rights, not makers of policy. As Aladi Krishnaswamy Iyer said, the judiciary in India will be the final interpreter of the Constitution. But it cannot be the final sovereign. Sovereignty rests in the people through parliament. The original cases were the narrow boundaries. The judiciary in its early years behaved like a cautious sentinel. Consider A. Gopalan versus State of Madras in 1950, the first great case on personal liberty. The question, could preventive detention violate fundamental rights? The court's answer was narrow, almost timid. It read rights in isolation, refusing to see the Constitution as a living, breathing whole. Liberty was curtailed, but the court deferred to the legislature. As was said in the judgment, each article of the Constitution must be read separately. They are not interlinked. Supreme Court, Gopalan in 1950. This was not judicial activism. This was judicial restraint. Some would say judicial abdication. But in 1950, the court saw itself as a body to interpret, not to innovate. Why did they hold back? Because the idea of judicial restraint was in itself part of the design. The framers had witnessed colonial judges strike down nationalist laws under the guise of interpretation. They feared unelected judges taking the role of rulers. And so, in the first decade, the Indian judiciary clung closely to the text. K. Munshi said, courts are not legislatures. Their function is to secure liberty through interpretation, not to fashion policy. Now let's look at the first signs of expansion. But even this phase of caution, seeds of expansion were planted. In State of Madras versus Champakam, Duraiarajan 1951 case, the court struck down communal reservations in education, citing violation of equality. Parliament responded swiftly by amending the Constitution itself through the First Amendment. Here lays the first battle lines. Judiciary said equality is absolute. Parliament said equality must bend to social justice. And thus began a dialogue, sometimes a quarrel, sometimes a collaboration between the legislature and the judiciary. But at this stage, the judiciary itself knew its mandate. It was a guardian, not a ruler. So let's bring it together. Act 1 of our trial shows us a judiciary that was cautious, even hesitant, a judiciary that respected the supremacy of parliament, a judiciary that often erred on the side of deference. It was the guardian of rights, yes, but it did not seek to become the sovereign of the governance. But history is not static. Crises create doctrines and doctrines create empires. In the 1960s unfolded the judicial phase, a new question. Can Parliament amend fundamental rights themselves? And in answering, the judiciary would slowly shift from guardian to something far more powerful. Act 2 about the rise of judicial supremacy. Act 1 ended with restraint, a judiciary cautious, differential, almost timid. But Act 2 is a turning point. This is where the courtroom transformed into a battlefield, where the judiciary begins to test the limits of Parliament, and Parliament begins to test the patience of judiciary. What emerges is the doctrine that will define India's constitutional destiny, judicial supremacy. The trigger, a single dangerous question. Can Parliament amend the constitution in a way that destroys fundamental rights? Let's talk about the Shankari Prasad era in the first round. The first shot was fired in Shankari Prasad versus Union of India in 1951. Parliament had passed the first amendment to protect land reform laws. Petitioners cried foul. Article 13 prohibits laws that abridge fundamental rights. Does a constitutional amendment count as law? The court said no. Quote, Article 13 applies to ordinary law, not to constitutional amendments. Supreme Court, Shankari Prasad, 1951. This was Parliament's victory. The judiciary retreated, but battles rarely end with one round, and this one would last decades. So the judicial rebellion started in the Golaknath case. In 1967 came the rebellion, Golaknath versus State of Punjab. A divided bench of 11 judges, the majority declared, Parliament cannot amend fundamental rights at all, not even to promote social justice. Why? Because fundamental rights are sacrosanct, beyond the reach of legislative majorities. As Justice Subba Rao quoted, then Chief, the Constitution is the supreme law. Parliament, being a creature of the Constitution, cannot enlarge or abridge its powers. Golaknath, 1967. With one stroke, the judiciary claimed supremacy over the amending powers of the Parliament. A seismic shift. From guardian, the court now had positioned itself as a rival sovereign. There was a political backlash. Parliament was furious. How could unelected judges block a land reform block redistribution, block social justice? Indira Gandhi saw this as a sabotage of the democracy mandate. So Parliament struck back through the 24th Amendment in 1971, expressly restoring its power to amend fundamental rights. And so, Act 2 hurtled towards its climax, the greatest constitutional case in Indian history, the Kesavananda Bharati case, and the basic structure doctrine. In 1973, Kesavananda Bharati versus State of Kerala, a bench of 13 judges, the largest ever. A clash not between men, but between visions of sovereignty. Could Parliament change anything, even the core identity of the Constitution? The judgment ran into thousands of pages, but the answer was single doctrine, yes. Parliament can amend, but no, it cannot destroy the basic structure of the Constitution. As H.R. Khanna quoted, the amending powers is wide, but not unlimited. Parliament cannot abrogate the basic structure, including the rule of law, judicial review, and fundamental rights. This doctrine was not in the text. It was not written in Article 368. It was judicial invention. Bold, audacious, revolutionary. Critics called it usurpation. Supporters called it salvation. But from this day, the judiciary ceased to be a mere guardian. It had crowned itself the interpreter of eternity. So there came a crisis, the supersession crisis. The verdict of Kesavananda was 7-6, a fragile majority, and Prime Minister Indira Gandhi did not forgive. Within hours, she superseded 3 senior judges to appoint Justice N. Ray as the Chief Justice of India. It was a frontal assault on judicial independence. The message was clear. If judges could strike at Parliament, Parliament could strike back at judges. As said by Indira Gandhi, quote, No institution can claim supremacy over the elected representatives of the people, unquote. History has a sense of irony. Within 2 years, the emergency would test whether the judiciary's supremacy was real or an illusion. In 1975, Indira Gandhi's election was set aside by Allahabad High Court for electoral malpractices. She appealed the case, Indira Gandhi versus Raj Narayan. The court struck down the 39th Amendment, which sought to put her election beyond judicial review. Why? Because free and fair elections are part of basic structure. The judiciary had spoken. Even the Prime Minister is not above the Constitution. As said by Justice Y. V. Chandrachud, quote, democracy is a basic feature of the Constitution and cannot be destroyed by the amendment, unquote. This was resistance, but it also set the stage for the darkest hour, Act 3, when judicial supremacy collapsed in the face of authoritarian power. So, Act 2 is a story of judicial ascent. From Shankari Prasad to Kesavananda Bharati, the judiciary claimed the final word on constitutional dignity. It created the basic structure doctrine, a weapon forged in interpretation, not text. But every weapon invites counterattack, and Parliament, under Indira Gandhi, was ready to strike. The stage was set not just for conflict, but for constitutional crisis. And so, we march into Act 3, the emergency. The night when liberty died, the judiciary stood trial before history itself. So Act 3 is about the darkness, the judiciary under emergency. Act 2 gives the rise of judicial supremacy, but every rise invites a fall. And in India, that fall came in the dark summer of 1975. The emergency, a time when democracy was suspended, dissent was silenced, and the judiciary itself was dragged to the dock of history. The emergency is not just a story of executive overreach. It is also the story of judicial surrender, when the very guardians of liberty locked the gates of their freedom. On June 25, 1975, Prime Minister Indira Gandhi declared an emergency under Article 352, citing internal disturbances. Overnight, opposition leaders were jailed, the press was censored, habeas corpus petitions flooded the courts. Citizens cried out, does the Constitution protect us when democracy is suspended? The answer, tragically, was no. There came the habeas corpus case, ADM Jabalpur case, the case that will haunt the judiciary forever. ADM Jabalpur versus Shivkant Shukla, 1976. The question was simple, the stakes enormous. During the emergency, when fundamental rights are suspended, can a citizen still approach the courts for liberty? The answer from majority, 4 judges against 1, was devastating. Justice Ian Ray said, when the Constitution itself is suspended, no person has any locus to move the court for liberty. ADM Jabalpur, 1976. The court declared that even if the stakes takes a man from his home at midnight, detains him without reason, and keep him indefinitely, no court can intervene. Liberty, they said, is not absolute. It exists only when the state permits it. The lone dissenter was Justice H.R. Khanna. But there was one man who refused to bow, Justice H.R. Khanna. His dissent is perhaps the most courageous judgment in Indian history. He wrote, even in the absence of Article 21, the state has no power to deprive a man of life or liberty without the authority of law. Even in the absence of Article 21, the state has no power. With that dissent, Justice Khanna stood alone. He knew the price and he paid it. He was superseded for Chief Justice, punished for defiance, but his legacy endures. History remembers Khanna, it forgets the majority. So let's talk about the judiciary's fall from grace. Why did the majority surrender? Some say fear, some say ideology, some say ambition. Whatever the reason, the consequence was fatal. The judiciary betrayed its own mandate. The guardian has become a servant, and the court that once claimed to be the basic structure's protector now legitimized the destruction. Later, Justice Bhagwati gave an apology in 1980s. He said, ADM Jabalpur was a mistake. We allowed ourselves to be carried away. I confess it as an embarrassment for me. This apology came years later, but for those jailed in 1975, it was too late. So, what was the impact of it on rights and society? During the emergency, over 1 lakh people were detained without trial. Newspapers were censored. Courts refused to hear pleas. Even the right to life seemed negotiable. This was not judicial independence, this was judicial collapse. And yet, the emergency was also a crucible. Out of this darkness came the realization that the judiciary could never again allow itself to surrender so completely. So, what are the reflections from emergency? When democracy was restored in 1977, the people punished the rulers at the ballot box. But the judiciary too was scared. It knew its reputation was in tatters. It needed to rebuild legitimacy, to reclaim moral authority, and so began the most radical phase of Indian judicial history, the era of public interest litigation, the era of judicial activism. Act 3 shows us the judiciary at its lowest ebb, a court that surrendered to authoritarian power, a court that told citizens, liberty is not yours unless the state allows it, a court that will forever carry the stain of ADM Jabalpur. But remember this too, out of surrender sometimes comes resolve, out of shame comes determination. And so in Act 4, the judiciary will rise again, but this time not as a cautious guardian nor a hesitant arbiter, but as an activist, a policymaker, a force that some would call a supersovereign. Act 4 of this lecture is about the activist court, from guardian to the supersovereign. Act 3 left us in darkness. The emergency had exposed the judiciary's failure. The people had lost faith. How could the courts reclaim their moral authority? The answer: by turning from restraint to activism, by becoming the people's champion, by stepping into governance itself. But in doing so, the judiciary would not just guard the constitution, it would begin to govern the republic. And thus, the question before us in this trial: did the judiciary save democracy, or did it crown itself super sovereign? So let's talk about the birth of public interest litigation. In the late 1970s and 1980s, a new jurisprudence was born: public interest litigation. The idea was radical. Courts opened their doors to anyone, not just the aggrieved, but any citizen, journalist, activist, even a letter on a postcard. Justice was no longer limited to those with resources, it was for all. As said by Justice P.N. Bhagwati, quote, where a legal wrong or a legal injury is caused to a person or to a determinate class of persons who cannot approach the court, any public-spirited individual can move the court for relief. S.P. Gupta versus Union of India in 1981. With this doctrine, Justice Bhagwati reimagined the court as a people's tribunal, no longer a distant elite institution, now a voice for the voiceless. The court also expanded the meaning of fundamental rights. Article 21, once narrowly read in Gopalan, now became a fountain of liberties. The right to life was no longer mere existence. It included dignity, livelihood, education, health, clean environment, even the right to sleep without disturbance. As said by Justice Bhagwati, quote, the right to life does not mean mere animal existence. It includes the right to live with dignity. Maneka Gandhi versus Union of India case of 1978. From that single judgment, Article 21 became the most fertile ground of Indian constitutional law. Almost every social right was read into it. The court had transformed itself into a policymaker. Judiciary became as policymaker. In the 1980s and 1990s, the Supreme Court issued sweeping directives. In M.C. Mehta versus Union of India, it regulated industries, vehicles and pollution. In Vishaka versus State of Rajasthan, 1997, it created sexual harassment guidelines, filling the vacuum left by Parliament. In Bandhua Mukti Morcha, it monitored bonded labor eradication. In Olga Telis versus Bombay Municipal Corporation, 1985, it recognized the right to livelihood for pavement dwellers. These were not judgments in the classical sense, they were governance orders. The court was no longer just interpreting law, it was creating frameworks, issuing guidelines, supervising implementation. Now let's talk about judicial overreach or necessary intervention. Was this judicial activism a savior of rights or a usurpation of power? On one hand, the judiciary filled gaps where the executive was apathetic or Parliament was paralyzed. Who else would protect the environment? Who else would create workplace protections for women? On the other hand, unelected judges were writing rules, issuing executive orders and monitoring compliance. Was this democracy or judicial oligarchy? As Justice Chalmeshwar said, quote, the Supreme Court cannot be a substitute for governance. Courts must be mindful that a populism is not constitutionalism. Unquote. The judiciary even began to step into political territory. In Kesavananda, it declared limits on Parliament's amending powers. In Indira Gandhi versus Raj Narayan, it protected electoral fairness. Later in TN Session versus Union of India, it empowered the Election Commission, and in 2G Spectrum case and Cold Drop case, it cancelled massive government allocations. Each decision strengthened accountability, but each decision also expanded judicial reach. The court was now the final arbiter, not just of law, but of policy and governance. Now let's discuss the judiciary as supersovereign. Let us pause and ask, when a court makes law, executes policy and supervises administration, is it still a court or has it become a parallel government? This is where the idea of judiciary as supersovereign emerges. As said by Upendra Bakshi, quote, the Indian Supreme Court has become the most powerful court in the world, not because of the text, but because of its interpretive audacity, unquote. Audacity, that is the word. To some, it was courage, to others, overreach, but none can deny. The judiciary was no longer the quiet guardian of Ambedkar's imagination. It was now the central actor in India's constitutional drama. So, Act 4 tells us the story of our judiciary that reinvented itself. From the shame of ADM Jabalpur, it rose as a voice of voiceless. It expanded rights, democratized access, and filled governance gaps. But in doing so, it crossed boundaries. It became not just guardian, but ruler, not just interpreter, but policymaker, not just sovereign, but super sovereign. And so we approach our final act, Act 5, the legacy and the dilemma. Did judicial activism save India's democracy, or did it create a new imbalance of power, where unelected judges decide the destiny of the nation? We began this trial with a simple question. Is the Indian judiciary the guardian of the constitution, or has it become a super sovereign? In the last 4 acts, we walked through history from the framers' intent to the triumph of Kesavananda, to the shame of ADM Jabalpur, to the rise of judicial activism. Today, we stand in judgment, not of the individual, not of the institution that has shaped the very destiny of our India. This is not a closing argument. This is a reckoning. Let us begin with its achievements. No one can deny that the Supreme Court has been the single greatest check on raw political power. When Parliament tried to alter the Constitution's identity, the court stopped it. When governments abused retention laws, the court eventually expanded Article 21 to protect liberty. When the state ignored the marginalized, the court opened its doors through PIL. In the absence of strong opposition parties or independent regulators, the judiciary has often been the only institution to stand between citizens and tyranny. As Ambedkar said, quote, however good a constitution may be, it is sure to turn out bad, because those who are called to work it happen to be a bad lot. The constitution can provide only the organs of state. The rest depends on the people and the political parties they create. Ambedkar warned us, a constitution is only as strong as those who work in it. In moments when parliament faltered, the executive trampled rights, the judiciary often rose to fill the void. That is its greatest defense. Without activism, perhaps democracy itself would not have survived. But here lies the dilemma. In protecting democracy, did the judiciary undermine it? Consider this. Judges are unelected. They are not accountable to people. Their decisions cannot be easily reversed. Yet, they have struck down constitutional amendments, cancelled government policies, supervised entire industries, dictated the guidelines where no law exists. In doing so, have they crossed the line from guardian to governor? As J. Chalmeshwar said, courts must remember the Constitution has entrusted governance to the executive, lawmaking to parliament, and adjudication to the judiciary. Transgressing these boundaries risk upsetting the delicate balance of separation of powers. This is the heart of the charge. Judicial supremacy may protect rights in short term, but in long term, it risks replacing democracy with juristocracy. Let's discuss the philosophy of judicial power. Legal philosophers have long debated this. Alexander Wickles called the judiciary the least dangerous branch because it has neither purse nor sword. But in India, the court has become the most dangerous branch. Precisely because it has moral authority. Its judgments carry the weight of legitimacy, even when they step into executive or legislative shoes. This is the paradox. Judicial power derives not from force but from faith, and when faith is absolute, so is power. As said by Upendra Bakshi, quote, "The Indian Supreme Court is a people's court, continuing constitutional convention," unquote. A continuing constitutional convention, in other words, the court is not just applying the constitution, it is rewriting it every day. Through interpretation, is that evolution or a revolution? Let's discuss the clash between judiciary and democracy. Let us ask a blunt question. Who truly governs India today? Parliament passes a law, but the court can strike it down. The executive takes a decision, but the court can stay it overnight. Citizens elect leaders every 5 years, but judges, once appointed, rule for decades. Is this democracy as designed or democracy redesigned by the bench? Bringing Justice Bhagwati's paradox. Quote, "We have broken away from the narrow confines of legal formalism. But we must remember, courts are not intended to govern the country." Bhagwati himself, the father of PIL, admitted the contradiction. He opened the floodgates, but he also saw the danger. Judicial populism is not constitutionalism, yet, once unleashed, it is impossible to contain. So, what is the crisis of accountability? This brings us to the problem of accountability. Judges wield enormous power, but how are they even held accountable? Impeachment is nearly impossible. Collegium appointments are opaque. Judicial review has no review of its own. In effect, the court has made itself the sole judge of its powers. It is judge, jury, and in many ways sovereign. Let's quote from the NJAC judgment 2015. Quote, "The independence of the judiciary is a basic feature of the Constitution. The primacy of the judiciary in appointments is essential to preserve the independence." Unquote. But independence without accountability is not independence. It is supremacy. So what is the future? Will it be a guardian or super sovereign? The question then is not just about the past. It is about the future in an India of 1.4 billion people with fractured politics, weak institutions, and rising executive centralization. What role should the judiciary play? Should it remain an emergency valve, intervening only when democracy itself is in peril? Or should it continue to act as policymaker, regulator, and governor of last resort? Bring in global comparison. The United States Supreme Court, despite its power of judicial review, exercises restraint in many areas. The UK Supreme Court respects parliamentary sovereignty, but the Indian Supreme Court, with its broad powers under Article 32, 136, and 142, is unique. It can do complete justice, and it often does, but at the cost of altering the constitutional design itself. Ladies and gentlemen, the trial of judiciary ends with no easy verdict. As guardian, it has been India's last line of defense. As super sovereign, it has often redrawn the boundaries of democracy itself. The dilemma is eternal. Too little power and rights perish. Too much power and democracy itself mutates. Let's quote Ambedkar one last time. Quote, "However much you may deny facts, they cannot be denied. You cannot escape the consequences of your own blunders." Unquote. The judiciary has been both a shield and a sword, but shields can become weapons, and swords unchecked can wound the very body they were meant to protect. That is the paradox of Indian Supreme Court, India's greatest guardian, and perhaps its most dangerous sovereign. Now we have walked through the chambers of history, we have examined the framers' intent, we have weighed the triumphs of Kesavananda and the betrayals of ADM Jabalpur. the audacity of PIL, the controversies of NJAC. We have listened to Ambedkar, to Bhagwati, to Chalmeshwar. We have seen the judiciary as savior, as activist, and at times as sovereign. The evidence is complex, but the charge is simple. Has the judiciary protected democracy or has it replaced it? The verdict is this: the Indian judiciary has been the guardian of our freedoms. Without it, perhaps India's democracy would not have survived the storms of emergency or the silences of parliament. But the same judiciary has also stretched its own boundaries, becoming at times more powerful than the constitution itself intended. Guardian, yes. Super sovereign, perhaps, and that is the dilemma we must continue to debate. Our democracy is not destroyed in one stroke. It is reshaped slowly by the overreach of each institution. The executive concentrates power, parliament grows complacent, and the judiciary, in saving the republic, risks becoming the republic. That is why the final responsibility lies not in the courts, nor in the legislatures, nor in the ministries, but in the people. It is the people who must remain vigilant. It is the people who must ask the hardest question of all: who judges the judges? This is not just a debate for lawyers or judges. This is the central debate of our democracy. The line between guardian and super sovereign will decide whether India remains a republic of laws or becomes a republic of men in robes. And you, that citizens are not mere spectators, you are participants in this constitutional dialogue. I am Bidhuri, a student of our constitution and above all, a citizen who believes that India's future depends on how honestly we confront these questions. This was the next hearing, India's constitutional dialogue series, where the constitution is not a textbook, but a living trial, where every episode is not just a lecture, but an argument for the soul of the republic. The court of history is never adjourned. It awaits the next case, the next hearing, the next judgment. Until then, stay vigilant, stay questioning, and remember, democracy survives not by silence, but by dialogue. Thank you.